Hello friends, and welcome back to the Supreme Court Historian YouTube channel. With this video we are going to launch our journey of investigating the First Amendment to the Constitution of India, and I have already made it clear that I really oppose that First Amendment, not its contents but its procedure. The contents, well, whatever the people and the people's representatives decide, they will be part of the Constitution unless they affect the basic structure in a negative way. But the procedure, could that parliament have actually amended the constitution? Did it have its powers? All of these were discussed in this case, Shankari Prasad versus the Union of India and State of Bihar, as the respondents, decided by the Supreme Court on the 5th of October 1951 in response to the First Amendment, which came into force on 18th of January 1951. So within a few months, within a quarter of the year, the amendment had been challenged by especially the landlords, led by this Mr. Shankari Prasad Singh Dev is his full name. We will look at the citation in a later video, but in this one I should upfront warn you that this is going to be the first of several videos on this landmark judgment, a judgment which, just like A.K. Gopalan, is going to require a lot of background and a lot of explanation, and just like A.K. Gopalan has been overturned later on, and just like A.K. Gopalan has been regretted by the judicial community itself. But all of that lies in store. In this video I am just going to discuss the background, and the sources for this background are basically these two books. I have discussed the first one before, 16 Stormy Days by Dr. Tripurdaman Singh, the story of the First Amendment to the Constitution of India. 16 Stormy Days is a brilliant book, a wonderful readable book, a worthy successor to Granville Austin's Working a Democratic Constitution, if my opinion is of any importance. The second book is out of print, but it is not unavailable. Land and the Constitution in India by H.C.L. Merillat. Merillat was a Ford Foundation scholar working in New Delhi in the 1960s, and he has written this book, which is available by the way, for borrowing on archive.org. I will leave this link in the description, so you can definitely take a look at that. You can quite clearly see that this is where I have got the screen print onto my presentation. Land and the Constitution in India, another very good source for this case and all relevant cases that came after this one. The origin of the case lies, as I've already mentioned, in the First Amendment. The First Amendment added and modified several things to our constitution, and it would be instructive to read what the government itself said when they introduced this bill. I'm looking at the Statement of Objects and Reasons for the Constitution First Amendment Act, and it makes for surreal reading. During the last 15 months of the working of the Constitution, certain difficulties have been brought to light by judicial decisions and pronouncements, especially in regard to the chapter on fundamental rights. Brought to light by judicial decisions, not by executive actions which led to those judicial decisions and pronouncements, especially in regard to the chapter on fundamental rights. The citizen's right to freedom of speech and expression guaranteed by Article 19(1)(a) has been held by some courts to be so comprehensive as not to render a person culpable even if he advocates murder and other crimes of violence. This is a direct reference to the Patna High Court's judgment, where Justice Sarju Prasad speculated that perhaps, as things stand after the Romesh Thapar and Brij Bhushan and N.B. Khare judgments given by the Supreme Court, perhaps even if somebody incites people to commit murder, even then that person would not be able to be prosecuted because he was simply executing his right to freedom of speech and expression. Justice Sarju Prasad's judgment, I have read out from that in the video that I have made on the ramifications of Brij Bhushan and Romesh Thapar. I will leave a link to that video as well. in the description. So the statement of objects and reasons is quite clear about at least this part, and also uh, in regard to the chapter on fundamental rights is mentioned, because when we look at what all was modified, we will very quickly get hints. The first thing that I'm going to talk about is clause 4, which was added to article 15. This is well, I'm sorry, I'm going to have to take up a little more of your time. I've scrolled down beyond where I needed to be. Here we go, finally. Article 15, clause 4, which was added, inserted by the First Amendment Act. Nothing in this article shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and the scheduled tribes. This is clearly a reference to the Supreme Court's judgment in Champakam Dorairajan versus the state of Madras, another case that we have spent significant time on. Champakam Dorairajan, of course, resulted in the Supreme Court annulling that communal order which provided for reservations in medical colleges and engineering colleges in the state of Madras based on caste. And so this clause was added to nullify the effect of Champakam Dorairajan. Quite a few other articles were also amended. I've listed them over here: 85, 87, 174, 176, 341, 342, 372 and 376, but they are not relevant to Shankari Prasad, and they are not really controversial either. What was also modified, Article 19, Clause 2, this was as a direct response to Romesh Thapar and Brij Bhushan. New grounds for restricting freedom of speech and expression were added. That is, public order was added as a ground for restricting freedom of speech. Friendly relations with foreign states was also added, and incitement to an offense was also added. Once again, a direct response, as I said, to Romesh Thapar, Brij Bhushan, N.B. Khare and Justice Sarju Prasad's pronouncements in the Patna High Court in the Shaila Bala Devi case, where she had published those pamphlets talking about goddess Kali requiring blood to keep the revolution going, etc. So all of these were held to be valid expressions, to be valid implementations of the freedom of speech and expression as guaranteed by Article 19(1)(a), and Article 19(2) gives the reasonable restrictions to those freedoms, and these three restrictions were added to those freedoms. I'm not going to read out from Article 19(2) because it has since been amended as well. So what appears in the Constitution today was not what was precisely inserted by the First Amendment. What was also modified in the in part 3 of the Constitution was the addition of two new articles, Article 31A and 31B. I'm just going to scroll down in this Constitution Amendment Act to that article in this act, to that section in this act rather, which inserted Article 31A. After Article 31 of the Constitution, the following article shall be inserted: notwithstanding anything in the foregoing provisions of this part, no law providing for the acquisition by the state of any estate or of any rights therein, or for the extinguishment or modification of any such rights, shall be deemed to be void on the ground that it is inconsistent with, or takes away or abridges any of the rights conferred by any provisions of this part. Specifically, it is talking about the right to property. If the state acquires any estate or extinguishes any rights in any estate or in any property by a law, the law under which such acquisition was made cannot be deemed to be void on the ground that it violates the fundamental rights, as long as that particular law had been reserved for the consideration of the president and has been assented to by the president. This would be a state-made law, not a central parliament-made law, but by a state legislature. And if the state legislature law had been reserved by the governors of that state for the assent of the president, and the assent had been received, then that law will not be valid. Basically, to give an analogy, it would be like taking away your home, but leaving you the front door. That is all that this assent of the president amounts to, because as we know, the president only acts with the aid and advice of the Council of Ministers. Also inserted was the new Article 31B, which became even more interesting. Without prejudice to the generality in 31A, none of the acts and regulations specified in the 9th schedule, nor any of the provisions thereof, shall be deemed to be void or ever to have become void on the ground that such act takes away or abridges any of the rights conferred by any provisions of this part. Overkill, sheer overkill, and tremendous problems could have been created by the insertion of this. The 9th schedule, as I have mentioned here, was also added to the constitution. The constitution had 8 schedules before that. It now has 12, but the most controversial addition, you might have heard the 10th schedule in discussion quite a few times, especially in the month of June and July in the state of Maharashtra. But the 9th schedule is even more controversial, and it gave the shield of being unavoidable to any act which was listed in the 9th schedule, not just from the day it was added to the schedule, but retrospectively, or ever to have become void. And to begin with, the 9th schedule contained 13 laws. The first amendment itself inserted the 9th schedule with 13 laws. Now, of course, when I look at the Constitution of India today, and you look at the list of laws present in there, they are all tenancy and land reforms and estate acquisition acts, almost all of them. But the list has moved up from 13 to 284, right? As you can see, nothing after 1991. We will of course be discussing all of that. I'm going to make a separate playlist for 9th schedule cases, in which this case, and indeed this first video related to this case, will be featuring as well. So quite a few things obviously modified by the first amendment, and this is a very short introduction to what all was changed and why it was changed. In the next video, we are going to discuss whether the amendment was required at all. Was this really necessary? Was going to such an extent? Was it called for at all? Why did the government end up taking such a drastic step? Couldn't it have been handled differently? All of that in the next video. I hope to see you then again. Bye bye.